Just to fill people in on the background of that, as best I understand, and feel free to correct me at any point, but the student, basically, the states in that were claiming that it was detrimental somehow to them, or a number of states were, including Nevada, that it was detrimental to them that students should be given relief from their student loans. Somehow, and how that impacts the state directly is a really tenuous chain that you're describing.
It was not only tenuous. Yeah. He actually found that for almost every state, none of them had standing.
Right. Okay.
He had to search for this agency connected to the state of Missouri that was not even a party to the case.
Right.
And he said, well, that means Missouri must have harm.
Right.
And so it was, but in the process of doing that, he used exactly the analysis that he never wanted to use to have to find standing because it related to scrap. And Justice Kagan reminded him of scrap.
Right. It's a superb example of regulatory capture when in reality there's no real harm done to the state whatsoever.
Yes, exactly. Yeah. Okay, so that's the one thing. That's about precedent. Mm-hmm. But let me go to the second question that you asked, or the second part of the question, or at least the second part of my answer to your question, which is very, and this is very important, and it's central to the whole meaning of scrap. That is, scrap as the model. Law schools in the United States all of them, no longer allow students to challenge corporate wrongdoing with the freedom that we have. Both of those things. They don't challenge corporate wrongdoing. They don't challenge it with with the freedom that we had.
Why would they choose to do that, and how legally could they stop them from doing that?
Well, they do it by, they've created over the last few decades something called the Faculty Supervised Clinic. And in the Faculty Supervised Clinic, none of them allow for challenges against corporate wrongdoing. Students instead get channeled into many other subject matters, but they don't get to make their own choice like we did. The faculty is strictly supervising their conduct, and their choices are very narrow. So the value judgments that get used here are faculty judgments, and more importantly, alumni judgments.
Yes, and
so you get to law schools, law firms,
right?
And so,
and of course, it couldn't possibly be that corporate contributions to fund these universities, as facilitated by said alumni, could have any impact on the direction that they would choose in that.
I have to tell you, Bill, if you, I think that's absolutely correct. But more importantly, if you were to look at the clinics that Yale University uses, their law school, as an example, and then you were to look at the clinics that the Antonin Scalia Law School uses, there's no difference. Neither one of them allows for challenges against corporate wrongdoing. They may have different imperatives, but money is at the base of both of them.
So presumably, if someone as a private individual, someone who was attending one of these schools, did this on their own, they would just be kicked out of the school, and that would be the school's policy.
Well, they would. They certainly wouldn't get any encouragement or support for it.
Right, and that's key to what you did. You were in an environment that fostered and encouraged that sort of activity. That's key to it.
One teacher allowed for it, and he had been denied tenure the year before for doing exactly what we've been talking about, and it was 800 students who signed petitions to get that reversed. And they got it reversed. Wow. And so it was exceptional at the time, controversial. The alumni didn't like it. The other faculty didn't like it. But out of that came not only Scrap, but a lot of other groups that did exactly the same kind of thing in front of federal and local state regulatory agencies, going after corporate wrongdoing. And it really mattered to students to be able to do that. I mean, it's an enormously practical, valuable experience in the law, and so. But what reemerged is exactly that mentality, only much better and more methodically implemented by law schools, faculty, alumni. How to channel students away from that.
I know it gets kind of lost in all this, and admittedly very important talk about standing and how this impacts the legal structure. But what actually happened to the freight rates from 1972?
Oh, they went down. They changed.
Good. Okay.
Now the commission. Well, not only did they change, then you get Congress doing a lot of things about what kind of cars do the railroads have, what are their schedules. Let's stop, building railroad tracks into steel companies. I mean, all those kinds of things that they did. A lot of that changed. And not that the railroads are any more conscientious than they used to be. This accident that occurred in Ohio, I mean, that accident, which really involved, the environmental harm and the human harm was enormous on that community. But the cause of the accident, it turns out, was wheels, the way wheels turn and friction from those. Yeah. Well, I can tell you, that problem's 100 years old. That's not something new. And so where are the law schools in Ohio?
So how do we get at that? If the problem ultimately is the faculty and the structure of the law schools, and perhaps outside pressure that's being applied to them, how do we create spaces in which engaged and active students can participate in this kind of activity?
I think that's a very good and a hard question. I can tell you that almost every day, as you know from your own experience, citizens groups, especially young people, have been very active. I mean, climate change is the most obvious example, but guns are an issue. Yeah, there are multiple others where you really see young people organizing out there. And it's not just the demonstrations, but it's the petition, it's to go to agencies of government. And just recently, although the lawyers were pro bono, were public interest lawyers, the group of young people in Montana that filed that law.
Right, that's an excellent example.
And so there is a role that law students could play. Even when I was a student, we had this course where we had this choice. And again, it only lasted a semester. We continued, obviously. But there were other students joining groups outside of law school on their own time. And it was just a matter of, would the law school be supportive or recognize them? And imaginative students can find ways of doing that. But in the end, the only way this will change, where some group of students or some students will have this freedom, this ability to choose and to challenge corporate wrongdoing, is students have to do it. That's what happened at George Washington University. 800 students signed this petition and insisted on a public hearing, and they got it. I described this in the book, what it was like. I was there. And students took on faculty members. Actually, faculty members denounced other faculty members for the way they voted. Reverse.
Do you think that the culture of students in this day and age, from what you can see, is up to the challenge that you guys were up to in 1972?
Gosh, I would hope.
I mean, the students themselves, if not the overall structure.
Well, I think they are. I think they're so underestimated, undervalued. Yeah. I think that one of the things I just talked about recently at a gathering, it was at George Washington University. One of the things I talked about wasn't what did we get out of doing this project and this experience, but what did we bring to it? And so when you look at that, I mean, these kids are 20, these students are 23, 24 years old. Yeah. They've had a lot of experience in life. They've seen a lot. They probably participated in community groups. They have family. I mean, the thing that we talk about in the book that was so important to us wasn't what was happening in Washington, D.C. What was happening in the hometown we came from.
Right.
What kind of harm did we notice already there? Mm-hmm. And we're in Washington, D.C. I mean, the law is all around us.
Yeah.
And so it isn't as if these kids are a blank slate. And when it comes to things like values, what do you think is wrong? Mm-hmm. Or what you might say is that's not right. Mm-hmm. It doesn't take by the time you're a second year or third year law student, it doesn't take some faculty member to tell you that.
Yeah.
Yeah. And then you have to use your skill like we did to do the research, to prepare the documents. I mean, we wrote there was two of us who actually wrote the complaint that the Supreme Court relied upon. Mm-hmm. Now, we had to get the lawyers we had a student who had graduated the year before us. He became our lawyer because we couldn't be the lawyer. We couldn't be the lawyers in court. We could be the lawyers in front of the agency, and we wrote the documents.
So it was somebody else who actually did the oral arguments before the court itself.
Yes, it had to be in the court. That's correct.
Right.
But we sat at counsel table. We wrote all the documents, right. And in fact, there was one judge, district court judge, in Washington D.C., Charles Ritchie. At the end of the oral argument, the professor who was our professor for that first term, mm-hmm. He got up in court. He walks to the podium. He introduces us. There was two of us there that day. Mm-hmm. He introduces us. Well, we not only stand up, but the judge thanks us for filing the lawsuit. And what could be more of an elevation of the importance of law students playing this role than being thanked in a form of gratitude in a public setting by a United States District Court judge? Thank you for this is a good thing, gentlemen. I mean, he couldn't have been more affirmative or more thoughtful about it.
Yeah.
And so that's that. So can students have those kind of values? They're underestimated. They're not given the freedom they should have. They're always going to act responsibly. That's what law school is all about. You're learning a lot, but you're also learning how to. You don't need to be learning the difference between right and wrong. Mm-hmm. And you don't want some faculty member who's whatever their age, cautious, uncertain, have been disappointed. You don't want them to be your guidance with respect to imagination or movements that you need to make, strategic choices. Yeah, they could be there to talk to, but it shouldn't be them managing you.
Right. And it really seems like the key difference that we need to make here in this age is one of encouraging and fostering and letting people engage and take risks at that age rather than discouraging them and saying, oh, you got to be careful of this, you got to be careful of that. It's going to have an impact on your career. Go this way because you're going to make more money. Go out there, take a risk. Especially as a student, you would think that is what you want to encourage people to do. That is the time that you're supposed to be doing it. And it can forge and obviously, given your example, transform amazing things in this country.
Well, I couldn't agree with you more, and I'm sorry that there isn't more of that going on. But students can change it.
Yes.
And I can say that at least based on my own personal experience, what you're describing was an asset to me. When I left law school, I went into the United States Department of Justice. Do you think anyone there asked me, Neil, do you know anything about regulatory agencies? Neil, do you know anything about lawsuits? Neil, do you know anything about appellate, how to argue a case or make? Of course not. Mm-hmm. I had sued the United States of America.
Yeah.
And within a month after passing the bar, I was in the United States Court of Appeals for the Fourth Circuit in Richmond, Virginia. I was the United States of America. Mm-hmm. Where did that come from? Well, among other things, it came from scrap.